Ron is going to join us, or has joined us with speakerphone, so his computer's updating. But we will begin the meeting. I'll call the meeting to order. This is a special meeting. The whole purpose is update on Senate Bill 2004, our budget bill. So Logan and Rebecca have a synopsis for us. So a lot's been happening, and we want to bring you up to date on what's been going on. So, Rebecca, take it away.
Okay. Good afternoon, everybody. So as Dave said, there's been a lot going on with the commission's budget. And we could just tell you guys what's going on in a very, very, very lengthy report, but we thought it would be better to really have you guys see and hear what is being said and talk about it a little bit more in depth so that you have a better understanding, and that way you can give us direction accordingly. So what we want to start with is the engrossed bill that came out of the full House yesterday. This is with House amendments. So if you remember, it came out of the Senate a few months ago, back in, I believe it was late January or early February. And so now it went over to the House. And I'm going to walk through section 1. Alicia, can you go up to the first page? So I'm going to talk about the actual budget portions of this bill and how it compares to the Senate version. So if you look at the base level that is on page 1, and then you have the adjustments and enhancements, and then you have the final appropriation. So if you look at the very bottom, this is the biggest thing on line 22, you will notice that it has a base level funding, or FTE, positions as 3, and that does not change in the House version. The Senate added the education and communication FTE, while the House removed that or didn't appropriate that. And so as a consequence, the funding in lines 17, 19, and 21, which really are just the same for us, or similar, excuse me, those do not have the funds for the FTE. So in the House, they removed both the funding for the FTE and the FTE position. The other thing that was debated a bit in the House was the case management system. So the case management system, after discussions and more research on our end, we came up with a number for the Senate at $50,000 for the case management system. Alicia just moved to section 2, and that is a one-time funding. So that $50,000 was put in there by the Senate, and it was maintained by the House, although the House funding has it as SIF funding instead of general funds funding. And so that ended up being very similar, but there was quite a bit of discussion about removing that case management, and in fact, it came out of the subcommittee without the case management system included. However, based on a motion and full appropriations that we'll talk about in just a little bit, that was added. On section 3, we don't need to worry a whole lot about. That is from OMB's budget and OMB calculations. That basically is the new and vacant FTE pool, which we already deal with. And then you can see section 4, that is where the SIF funding comes in. And the SIF funding is for that $50,000 for the case management system, which basically designates that it's coming out of SIF funding, not general funding, for that $50,000. This is different than the Senate version. The Senate just has it general funded, so they will have to figure out where that funding comes from. So those are the budget changes. To be honest, there's really only one. We lost the FTE from the Senate to the House. That is the big budgetary change in the budget bill. But what ended up happening is that we had quite a bit of policy that got attached to our budget. So I'm going to have Logan walk you guys through the budget portions of Senate Bill 2004.
And typically, that's not a standard practice to add policy to budget bills. It's done, but it's not a standard policy, is it? Would we call
No,
it
not
that?
usually.
Not usually.
So the commission's initial bill in 2019 that set up a lot of the procedures, and that was actually an appropriations bill. It included the initial appropriation for the commission and then all the policy back in 2019. But generally, the legislature doesn't do that. They combine policy with appropriations. There are exceptions to that, but it's not a general practice. Okay. So a lot of this will look familiar to you because it was included in two policy bills earlier this session that you are very familiar with, both House Bill 1360 and House Bill 1505. Starting with Section 5, this is an immunity provision the House added for this criminal statute 12.1-13-02, speculating or wagering unofficial action or information. This is borrowed from House Bill 1505. The same language, same provision, same immunity provision. Now it's just on our budget bill. Same thing with Section 6, that also came from 1505, again, now on our budget bill.
Do you want to talk about what happened with the
You
with
go
House?
ahead.
Okay. So just to refresh everybody's recollection, House Bill 1505 was defeated by the House, so it did not pass. So these provisions that were included failed on the House floor. They also got a do not pass coming out of committee. And so they are being added back on to the budget bill. And that's why they're adding them back on. I guess I can't talk about intent, but the fact is they did not pass the first time, and now they're being added back on here.
And not in their totality either, just certain pieces of them. So those two sections were from 1505. But now if you move on to Section 7, and this is what we're going to.
Ron's on now. Ron, did you just get on a meeting?
Sad?
Yep. We have Ron now.
Yeah, I'm here.
Instead of on the phone.
Okay. So Section 7 of the bill, and this is, again, what we're going to focus most of our discussion on, I think, today, because this is the confusing section for us, is this issuance of alleged violation, closure of the matter. Some of this language is from 1360 and I believe 1505. Certain aspects, they overlapped in some respects. So this language is borrowed from one or both of those two bills in lines 2 through 4. Upon completion of an investigation, the executive director shall prepare a report and recommendation to the commission to close the matter or issue an alleged violation. The commission may issue an alleged violation, require additional investigation, or close the matter. So that piece of policy works in the context of 1360, but as we'll talk about as we go through the meeting, it doesn't work in the context of our current complaint process, which is not fundamentally changed with our budget bill. But that language appears here, so it is confusing why it's in the bill in the first place when we're still dealing with the same complaint process that we have today. But then it adds a line or two lines, a line and a half, in 5 and 6. Each case must be closed within 180 days of receipt by the commission of the underlying complaint. So what that language does is impose a 180-day deadline on the commission to receive, process, and complete complaint investigations. And we'll talk about that as we go through the meeting, but that's the new piece. That's not borrowed from 1360 or 1505. That's new language that appears in our budget bill. Moving along to Section 8. This is regarding the confidentiality provisions that apply to complaint investigations. What they do here is add that a respondent again, the term in statute is accused individual, but a respondent can now speak publicly about a ethics commission complaint investigation. Section 9, and that was also borrowed from 1360. Section 9, this is from 1505, language from 1505, regarding the Legislative Assembly's conflict of interest rules. They're aligning the statute with what the House's rules are currently, where they remove the words direct and substantial and narrow it down to unique and individual. That's not new language. That is also from 1505. And then section 10, the last policy section, one of the last policy sections here. This was moved by Representative Carla Rose Hansen in the subcommittee to add this annual report to have the commission complete each fiscal year, just giving the public and interested individuals information on the commission's work. That was the goal of that amendment. Scroll down. And then the last section, section 11, is an emergency clause for 5, 6. So the immunity provisions for legislators, the 180-day deadline, the confidentiality provision, and the conflict of interest rules for the Legislative Assembly are emergency measures with this section. So if they get enough votes in both houses and they're signed by the governor, they don't become law on August 1st, they become law immediately. Any questions so far?
How many votes do they need to get?
2/3. I don't know the exact number, but it did pass the House with 2/3, so the emergency clause carries for now, at least,
In the House.
in the House.
Any questions on just the bill thus far before we get into the discussion that was had during the committee work?
This is Ron. Will this be retroactive for our old cases as far as that 180 days is concerned?
That's a good question, Ron. It's unclear at the moment. There was some discussion that is what their intent was, but I don't know if that's what the plain language of what the amendment says either. So we're hoping there's some clarity as it continues to move through the process, what both in their intent and the language, but that's fluid at the moment.
And there's no provision that I can see for extending this time under an emergency. As we know, there are times when that will be a very, very difficult goal to reach.
Well, Ron, the problem is it puts an enormous constraint. You know, our process, the investigations that staff has done here, the thorough process that we use, that's contained in statute. Well, this just basically circumvented that.
Yes.
Well, what I thought could happen is you could have people who had a complaint filed against them stall in getting you information, which would take you past 180 days, and so then it would be dismissed.
Correct. And the problem is with the emergency clause, anything that's already past 180 days would be dismissed.
It could be.
It could be.
So one potential interpretation of this, if we look at the plain language of the directive, is that each case must be closed within 180 days of receipt by the commission of the underlying complaint. So if this goes into effect on May 1st, for example, if a case, yes, it may not be retroactive, which is debatable whether it is or not.
Legal question.
It's a legal question. But then the secondary legal question would be, okay, so even if it is not retroactive, on the day that it goes into effect, if a complaint is more than 180 days, is the directive to dismiss that? So maybe it doesn't apply retroactively, but once on the day that it goes into effect, do we go back 180 days and dismiss anything that is older than that? Is that what the intent is? I'm not sure, Ward and Dave. That certainly is a reasonable interpretation, something that we need to do more research on.
Okay, I see. Am I on?
Yes.
Yep.
Yeah, okay. I see that Representative Ista had made some comments regarding the Constitution. Maybe controlling on this. He says he notes that the Constitution Amendment says the legislature may not do anything to impede the implementation of the work of the commission. So
Ron, do you, oh, sorry.
Go ahead. No, I'm kind of,
Go ahead, Ron.
it seems to me then that the Constitution would carry here as far as the work of the commission is concerned. Maybe I'm not putting it very, very well, but any comments on that?
Rebecca, if the this bill is enacted as it states, how many complaints are over 180 days?
Old.
Oh,
Okay.
prior to.
Yep.
Let's say that it's passed as is and becomes effective on May 1. How many complaints would the legislature direct the Ethics Commission to dismiss?
If we go back 180 days, it would effectively direct the Ethics Commission to dismiss 28 complaints if it was enacted or became effective May 1, under the interpretation that we talked about.
Okay. And of the 28, how many of those would be legislative complaints?
17.
So in effect, if the bill is enacted as written, the legislature would be dismissing 17 complaints against their own members.
Correct. They'd be directing us to do that.
Directing, yes.
That's one interpretation,
Yeah,
yes.
okay. Ron, does that kind of answer? I have the same question. Does that kind of answer your question?
It does, but I still see then a conflict between this and the Constitution, in the sense that the Constitution should rule, and if we have a situation where we carry over a case because we simply cannot meet the 180-day requirement, and I don't know the wording of the Constitution, but it seems to me that that's gonna be a question that maybe the Supreme Court has to answer.
Ron, the provision you're referring to is Article 14, Section 4, Sub 1, and it states, quote, laws may be enacted to facilitate, safeguard, or expand, but not to hamper, restrict, or impair this article. So to answer your question, I think both you and Representative Ista raise an issue that we will certainly have to analyze thoroughly, but today I'm not prepared to give you a yes/no answer.
Okay, I think we just have to leave it at that.
Any other questions, or are we good to queue up the video to walk through some of the discussion that was had by the committees?
For Cindy, got any questions or comments?
Okay.
All right, Alicia? So
They need information from the person filing the complaint, or they need,
okay. So what we're going to do is we're not going to go through this entire discussion. I think the entire discussion took a little bit over an hour, maybe not, I guess 40 minutes. But we do want to kind of direct your attention to certain portions of this discussion and comments that were made, and really just provide the commission with some analysis. And maybe what we would have responded to, this is committee work, so we don't get an opportunity, the commission does not get an opportunity to comment or respond unless asked to come up and answer a question, which did happen at one point, but we're not going to play that portion because you all know the answer to that question. So with that, we're going to start with Representative Lauser, who's introducing the amendment. And we skipped over the money portion because I already shared that. So we're going to talk about his introduction of what I would say is the policy portion of our budget.
third-party information that they're not getting responses. We had a bill earlier in the session that, as prior to introduction, offered subpoena power to the Ethics Commission. That was not in the bill, and then the policy bill was ultimately defeated in the House. But what we're addressing here is giving the director the ability, or the commission the ability, to close a complaint if 180 days pass and there isn't any action. We've got a couple that I think are over 2 years old. And so we're saying, we're giving, there's a little bit of discrepancy whether the director and the commission has the ability to close complaints. But in this case, we're saying if 180 days has passed, we're giving them that authority.
Okay. So did you pause? Okay. Sorry, just to know he paused. Or... Okay. So just to, that was Lauser's, Representative Lauser's, just kind of introduction. What you'll notice is throughout the committee work, several legislators refer to this 180-day deadline imposed or directed to the commission in Section 7 of the amendment as a tool. That is the language that they are using. You'll notice Representative Lauser uses that here. Really what this is doing is it's creating this idea that after 180 days, the commission will be able to close things, and that this is going to help the commission's work. So in reality, or in practice, what we deal with on a daily basis is that the underlying issues and complaints, if we're not able to get all that information done within 100 or compiled within 180 days, the underlying ethical issue is really not going to be addressed. And instead, what's going to end up happening is that we're going to allow ethical concerns to fester, to not be addressed, because the legislature is directing the commission to dismiss things without actually reaching what we call a resolution or a conclusion on the merits of the complaint. So those are two things that we just wanted to point out in kind of describing what Representative Lauser said. He also referenced, Representative Lauser also referenced that there seems to be a discrepancy on whether the director or the commission, he somewhat interchanges those words, has authority to close things, meaning close complaints. We're going to address that in later comments. There's some additional comments that are made and that are a little bit more thorough, but that is what we wanted to focus on with Representative Lauser. Any questions, comments, concerns from the commission on that one? Okay, with that, we're going to move on to our second snip, let's call it, that we're going to walk the commission through. And this is Representative Carla Rose Hansen, who is speaking.
The other concern I have, committee, related to the bill in front of us is related to the policy. So if you look at section 6, we say that each case must be closed within 180 days of the receipt of the complaint. Going back to the measure that was passed by the people in 2018, in section 4 of Article 14, it says that the laws that we enact as a legislature may not hamper, restrict, or impair the Ethics Commission's work. All of us want to see these complaints be resolved as quickly as possible. I'm sure it is no fun to have a complaint hanging over your head, but this time limit that's specified in this bill could be viewed as restricting that process, and it could be viewed as unconstitutional and conflicting with Article 14. So taken all together, my concern is that this budget is setting up the Ethics Commission to fail. The Ethics Commission is seeing this huge influx of cases, but during our section meeting on Monday, we said no to adding more staff capacity. And in the absence of adding that FTE, we said no to adding additional dollars to make up for that for external counsel. We also said no to this system that they asked for to help track all these requests. Right now, those are handled manually, which is inefficient and ineffective. And then we also said no to giving them better processes, because the Ethics Commission had provided testimony that their current processes include several bottlenecks that prohibit them from dispatching with certain cases in an efficient way. So with this version of the budget, we're asking the Ethics Commission to resolve a record number of complaints in a specific period of time, but they have to use the same amount of staff, just a small amount, a bit more of external counsel, the same manual tracking system, and the same bottleneck-filled complaint process. So committee, I would hope that we would restore that FTE for education and outreach, and potentially make some other changes related to the policy aspect too. So thank you, Mr. Chairman, for letting me show that.
Representative Nathan.
Thank you, Mr. Chairman.
So just a couple comments there with Representative Hansen's comments she made in the committee. She did reference the case management system that did get added back later in the committee here, or the committee work. But she did, when she was speaking, raise some of the same concerns that we share as staff, but also that Ron articulated earlier, and then Representative Ista did raise on the House floor as well. So that's, I guess, our comments for that clip. I guess the next representative he's moved to is Representative Nafee.
Discussion, as Representative Hansen said, and this is what we've come up with. In regards to the time limit, the 180 days, a lot of discussion on that. And I had asked a question of the director as far as why aren't they pushing these out. And basically, the complaint process is driven by the complainant. They almost practically need the permission from the complainant before they close the case. And I had mentioned, well, the Attorney General's office said they have the authority. The director from the Ethics Commission says she doesn't have the authority. So you have two lawyers disagreeing on the interpretation of a law, which is nothing new, right? That pretty much happens pretty steadily in the legal field. So your committee came up with, hey, let's give them 180 days. Let's give them the tool to push these cases out. There's cases that they're sitting on 2-3 years. I mean, there's felony cases, murder cases that get pushed out quicker than these, right? So let's give them the tool to move these cases out, because it is not fair to the accused that this hangs over their head. You take a look, as Representative Hansen said, 2023, they had 15 complaints, 24 up to 41. This process has been weaponized by people going after our colleagues. Just the complaint alone is what they want. And then the complaint sits and it's mired in muck. It's kind of really wanders aimlessly. And we ask what's going on. And if the commission does kick one out to the state's attorney, don't hold your breath that the state's attorney will prosecute it. That's a whole nother discussion, whole nother step. We had one case that we all know that was prosecuted, but I know of other cases that they pushed and the state's attorney said no. So again, nothing wrong with putting 180 days on it. They can take a look at it and if they think there's something there, then they move on with the case. If there's not, then you kick it out the door.
All right, so there's a lot to unpack with what was said in this last clip, but we wanted to kind of give the commission an overview of some of the points that he made so that we can talk about this. So first off, Representative Nathy starts out his discussion, and he says it several times that there was a lot of discussion. I want to be clear with the commission that when I think what he means when he's talking about a lot of discussion is the discussion maybe in the committee. There was not a whole lot of discussion on the amendments that happened in the committee work. Those did happen pretty quick. But he then later references other discussions with the Attorney General's office. What I want to be really clear with the commission today is that in those discussions that are referenced by Representative Nathy, I was not, or the commission staff was not included in those. So when we talk about a lot of discussion, I don't want there to be the impression that we were having a lot of back and forth on these particular amendments, the policy amendments, particularly the 180 days. We'll talk about this later, but that we were not consulted on the 180 days. The other policy things were previously spoken about, but that was a little bit of a different context, and we'll talk about that in a little bit. So I'm going to then hand it over to Logan because of to walk through the complaint process and kind of a response to that the complaint process is driven by the complainant.
Before we go there, so what the commissioners we should consider, notice how they reference that policy as a tool. That's not a tool. A tool would be if they gave us our FTE. A tool would be if they gave us our case management. Giving a restriction, an arbitrary restriction, is not a tool.
So I'm going to have Alicia pull up the Century Code and the complaint rules, because throughout legislative session and even before, I guess, there's a lot of discussion about, well, you have the authority to dismiss things, or we say that the complaint process is driven by the complainant. And I guess to clarify, we'd like to show you how we're interpreting it and why that is the case. So the commission is very aware that we have what we break down into a 3-step process. You do step 1, an initial review to essentially check whether the commission has jurisdiction. Then once you're done with that process, you move into informal resolution, where the commission is in this strange circumstance where it has to then turn around and try to mediate a complaint between the complainant and the respondent. And only after that process is done does the commission get to exercise its constitutional authority to investigate. So when we refer to the complaint process being driven by the complainant, what we're talking about is informal resolution, which is in statute on your screen there with 546607. So if you read it, it says the commission shall attempt, shall, as in mandatory, required, not may, shall attempt to negotiate or mediate an informal resolution between the accused individual and the complainant unless the commission summarily dismissed the complaint under section 546605. And then it says the accused individual may be accompanied by legal counsel in a negotiation or mediation. So when you read that section following the statutory process, informal resolution is a required step where the commission is asked or directed to mediate a complaint between a complainant and a respondent. And when you're mediating something and the complainant has a bone to pick, for lack of a better term, with the respondent, they are driving the process. They control the resolution. They get to tell the respondent, I will not settle this case unless you abide by my terms. And that is the complainant in the driver's seat. You cannot reach a resolution until they agree at this step. So that's what we mean by the complaint is complainant driven. They get to decide that issue at step 2. But then if you move along into 546608, it says if an informal resolution is not reached under section 546607, the Ethics Commission may dismiss the complaint. So there's some comments that Representative Nathy made that said his interpretation from the Attorney General's office or wherever he's receiving it from is that it's two lawyers disagreeing on an interpretation of law, and that the commission has the ability to dismiss things without a change to the complaint process. There is a huge caveat to that, though, because if you read the statute, it says if an informal resolution is not reached, at that point, the Ethics Commission may dismiss the complaint. But keep in mind, at this stage, the Ethics Commission has not been able to investigate, corroborate, look into the facts of the complaint, essentially review the facts of the matter in any substantive form before it's being directed, well, you can dismiss a complaint. Yes, that's true, but the commission may not exercise any of its constitutional powers if you're following this process to investigate at that stage. How does the commission know what it's dismissing if it hasn't investigated any facts of the matter? So then if we go to our complaint rules, currently in the complaint rules, this is in the administrative code where the commission's rules are. So this is the complaint rules. In section 115-02-01-06, under complaint investigation, the commission has directed the executive director to conduct an investigation of any complaint which is not summarily dismissed or resolved through informal negotiation or mediation. So when the commission was setting up its complaint rules, it directed staff and itself that if a complaint is not informally resolved, the commission is going to exercise its constitutional authority as directed by the voters when it created the commission to investigate a complaint, to reach the merits of the complaint, to find out what the facts are, and provide it to the commission so it can make a fully informed decision before it is just arbitrarily dismissing complaints just to get rid of them. So that's how we interpret. Yes, there's that statutory, you may dismiss things, but at that point the commission hasn't even done any fact finding or investigation, so how can you know what you're dismissing without the facts?
And remember, the statement was made that we get a complaint and it sits there. Well, the legislature established a statute that we have to follow, so it doesn't sit there. We're following statute, then we set up rules to properly execute what our constitutional duty is. So the statement that it just sits there is just silly.
So, again, in what Representative Nathy was commenting on, he again referenced the phrase that the deadline is a tool. I just want to point out to the commission that if we are asked or directed to dismiss complaints after 180 days, that's a fairly short turnaround. So we would invest quite a few resources in investigating that and getting documents and getting time. And if we can't get it done within the 180 days, what could end up, by following the arbitrarily imposed deadline, really what we could have is we could have quite a bit of work, quite a bit of resources put into something, and then end up having nothing as a product because we just have to close it. So it really could end up wasting quite a bit of resources. And ultimately, I don't think that, in my personal opinion, I don't think that this is a tool for North Dakota citizens. If an investigation is closed without it being meaningfully resolved, so there is a difference between something addressing an underlying issue through resolution or just closing something. And the citizens in North Dakota end up not getting the information that they would get if we would reach a resolution, whether somebody did or did not commit an ethical violation. So I think that is a mischaracterization, but again, we just wanted to point out again that there was that reference to using that 180-day deadline as a tool. And then I'm going to have Logan talk about one other thing that is happening in the process and that Representative Nathy brought up.
Yeah, so Representative Nathy in his comments, he talks about criminal referrals, and he doesn't really get into that because he says that's a whole other discussion to have. But it actually directly impacts the commission's work and the timeline when you're discussing a deadline. Section 546608 sub 2 of the Century Code, as the commission is well aware, it requires the commission to refer complaints to law enforcement if the commission, quote, believes a complaint contains allegations of criminal conduct, unquote. That's a very low standard to form a belief, and then once that belief is formed, again, the commission is very well aware of this, that referral is required by statute. And then the commission must pause any of its work on that investigation in the meantime. So, for instance, the criminal referral mandate that's in the statute could result in something sitting on the state's attorney's desk after the commission has referred it for the entire 180 days that the commission has to do its work. When the commission would receive that complaint back, regardless of whether the state's attorney decided to prosecute it or not, the commission would be required to dismiss it by this deadline proposal. So I think there's a few more things that Representative Nathy says that we have in this clip for you.
Any questions or comments so far? I mean, there's a lot going on here, but you can see kind of the theme of what we're presenting is they're providing kind of they're kind of telling the commission what to do and they're not giving us the resources.
Okay. Without any comment, we'll go to the next. This one's a short clip, shorter.
Going up, but quite frankly, it's going up because there's no real leadership from that ethics commission. As Representative Hansen stated, Representative Lauser stated, he called to get an opinion. Can I or can I do this? And they're getting kind of this milquetoast gray answer. And that's what's happening. Everything is going with the complainant, not with the accused, and it's not fair to the accused. So there needs to be some more definite things, quite frankly, I mean, the Ethics Commission has a tough job to do. I don't doubt that one bit. But there needs to be more leadership, and there needs to be more decisiveness as far as what can you do, what can't you do. And this 180 days is going to give them that tool to say, you get it done now in 180. Because if we don't, it's going to still languish, and these cases are going to sit there forever. And that's not what the people voted for.
So Representative Nathy's comments, he continued on this, and we really want to address the comments that he makes. He talks about getting milk toast answers or great answers from staff. And so the commission might be wondering, what is he referring to? Or, he specifically referenced Representative Lauser reaching out. So when a public official or a lobbyist has a question, those of us in the commission's office walk a very fine line. We are not their attorneys. We do not represent them in their personal capacity. We are the staff of the Ethics Commission. So we have to walk a very fine line. We can provide them with information, but we can't necessarily provide them with advice, legal advice. So we have this very fine line that we do have to walk, but we also do want to be helpful. And so what we do is we direct them to resources. We direct them to analysis that they can look at so they can then help themselves and make that decision. If they want a firm yes or no answer, the proper channel that's currently established to do that is through an advisory opinion request. The hope is when we do pass the rules regarding informal guidance, that is another avenue for them to get that firm yes or no answer. And so we just wanted to address that. We think that is what Representative Nathy is talking about. And then again, he references the deadline as a tool once again. So you can kind of pick up on the conversation up to this point. So I think we'll move on to the next one.
Representative Hansen.
Thank you, Mr. Chairman. I just want to respond to one of the comments about, I'm concerned about framing the Ethics Commission as having a lack of leadership. I object to that a little bit. The leading up to the legislative session, the Ethics Commission worked with the leadership of the majority party to put together House Bill 1360 and House Bill 1505 to create solutions to some of these bottlenecks, to create better processes so that we could resolve these complaints that are coming in faster and faster in a more efficient way that is fair to all parties. And so I want to object to that description because I think there was a lot of work put into trying to find solutions so that this doesn't keep happening.
Just a quick comment here. What Representative Hansen is referring to, she's speaking about the policy bills the House killed earlier this session that have now, there's language borrowed from them that's now put in the appropriations bill. And those are House Bills 1360 and 1505. And again, it's our view that those two bills would have addressed all the issues the House was bringing up in the Appropriations Committee that day. Specifically, they referenced weaponization, closing matters, all of those things were addressed in House Bill 1360, and we had that discussion with the Policy Committee. So I think we have, just quick on that one, but moving along to the next
Can I
one.
just ask, I'm a little bit slow here, but Rebecca, just going back to your prior comment about walking a fine line when responding to inquiries. What would be the risks to you or to the staff if you did provide a specific answer to a specific question?
So there is a possibility that could be interpreted as Logan or I as providing legal advice to somebody who is not our client. I'm not saying that's 100% accurate, but that could be an impression, and that could put Logan and I in a position of a potential ethical violation with the professional rules of conduct in the legal profession. So
That's the fine line that you're talking
that is
about.
the fine line. So we always ensure that people know when we are communicating with them that we are not their attorney, although we are attorneys, but that we are providing them with the information for Logan of his client as the commission, and then for me as my employer, what the commission has said or explains, or the analysis that the commission has provided. So we walk that very fine line.
And could it not also come back to haunt us, Rebecca? I mean, I'm sorry. I got to say what I got to say, because again, they call and expect you to say yes or no, because they want a yes or no. And then they can come back and say, well, Rebecca and the North Dakota Ethics Commission said yes. And so I shouldn't be in trouble because I mean, it just, yeah, sorry. But
No,
yeah.
Cindy, you're exactly right. And where it gets difficult in that is because sometimes people are very open and they share all the facts with us, but there may be facts that we don't know about. So we can't assume that we have all the facts when we do an analysis, when we may in fact not have them. So that is why the whole point of education is to provide tools for people to be able to make that decision on their own behalf, right? Now, if they have a really specific question, how we usually handle it is if they call us and say, ask a question, and if there's a statute that says yes or no, we direct them to that statute. Go and read, 5466.054 or whatever. I don't think there is anything that's that statute, but that's what we do. Yes,
Yeah.
But Cindy, that's a very good point.
Thank you.
Okay, let's go to the next one.
Representative Murphy, these policy language amendments that we see here came as a result of the two bills that Representative Hansen referred to in the first half of the session. And those involve talks with leadership from both chambers and talk with the leadership from the Attorney General's office and the Governor's office. By crossover, they couldn't come to an agreement. It comes after crossover, it comes to us. We got the budget, which originally we didn't, and then was asked to address these policy language and to work with all interested parties. So your committee was more or less the middleman between there. So this amendment, the wording is all as a result with many, many discussions with the Governor's office, the Attorney General's office, and the leaders. And I'm certainly not a lawyer, but believe me, there are plenty of lawyers involved in crafting this. And so Representative Murphy, I can't tell you the exact reason why. I would just suggest maybe talk to one of those entities and they can give you a far better answer than I could.
So this is just for the committee, it's kind of information on a follow-up question that's going to happen in a little bit. I just want you to keep Representative Nathy's comments in mind about the discussions that he was having at that time. He is going to be later questioned about these talks, but we just wanted to share that clip to provide a basis for that. And now the next one we go to is Representative Nelson.
Thank you, Mr. Chairman. Representative Lauser, you and Chairman Nathy mentioned the tools that Representative Nathy brought that this limitation, this 180-day limitation, is one of the tools to help them do their work more efficiently. It takes me back to when my son was running track and when he'd lose a race, he'd come to me and say, well, what can I do? What can I do better? I said, well, you're just going to have to run faster. And that kind of looks to me like that's what this piece does is, I don't know how much of a tool that is to get the work done. The other tools that I see in the long sheet are the FTE, albeit it's for an education and communication piece, but Representative Hansen did say that workload would allow some of that backlog to be addressed if that individual was hired. And the other piece was the case management system that might be considered a tool. But looking at the parentheses around the funding for this, that isn't offered as tools in the House version. What other tool is there other than a time limitation on the 180 days?
So there, Representative Nelson asked a question. He says, what other tool is there other than a time limitation on the 180 days? And that is a great question. If the legislature wants to give the Ethics Commission a tool, there's certainly tools that they could give it, and that could include a clear subpoena process, for example, or reforming the complaint process to make it efficient and address the problems the commission runs into. Another one could be providing additional resources like the FTE that was requested to free up other staff's time and resources for investigations and complaint matters. And then the one that he did bring up as well is the case management system. So I guess the first two that I referenced, the clear subpoena process and reforming the current complaint process, to note, they wouldn't require any additional money. It's just a hard conversation to approach with the legislature. So that's how we would have answered the question if we would have been asked in the committee work, but we'll let Representative Nathy's answer play.
Well, Mr. Chairman, Representative Nelson, really the 180 is, as Representative Hans said, we talked about that probably more than anything in this bill. And we had a lot of discussions with the executive director as far as, again, moving these cases out was the real big thing. We went through this. So the 180, we came up with 6 months to work on it, to move it out. We can come back here next session and say, hey, 180 is too long, 180 is too short, and we can adjust it there. But again, the main reason why we had it is because the Attorney General says they have the authority right now in the Constitution that was passed. They can move these out at their will. But then the executive director says, no, we can't. So they both interpret the law differently, okay? So we're saying, okay, I mean, kind of judge and jury, we're going to say 180, and you go from there, so.
So the next clip that we're going to play
We should talk about that though.
Okay, sorry.
So when the Attorney General said that we have that ability, but remember, the statute says we have to do this first. So we have things that have to be accomplished according to statute the legislature approved. So we can't just hurry things up like the Attorney General says. It doesn't work that way. If they look at the statute, there are procedures we have to follow, and this is what the legislature set down for us previously. So to say that we could do this already is just not correct.
Well, I suppose it could be considered correct if after 180 days, we simply dismissed a complaint and took it out of the process, and then the complainant would have to bring the complaint again. But that doesn't accomplish anything. And another comment I wanted to make regarding the subpoena. We brought up a subpoena probably I'm thinking way back. We brought up a subpoena power of some kind back in 2018 at one of our first meetings. And of course, we haven't gotten that yet. That would hurry things along, but we don't have that power.
Ron, I think you guys even brought a bill in 2021, if I remember correctly.
There was a bill in 2021 to clarify what that process would look like for the commission.
Yeah.
It's not necessarily that the commission doesn't have that power, it's just there's no clear process. So how do you walk through it without any direction on how to secure one?
Well, we talked about it nothing was brought up in the legislature, but we talked about doing that in 2019 of giving us a subpoena power of some kind, but it was never part of a bill. So it does go back a while.
Okay. Ron, are we good to move to the next one? We have just a few left.
Yes, I'm fine.
Okay.
Ward or Cynthia, do you have any questions or comments?
Not at this time.
I mean, there's a lot coming at you here, so we just want to make sure that if you have a question, you have the opportunity to bring it up.
I've got a lot of questions in my mind as to why we're being treated like this, but that's for another day.
Might be for today, Ward.
Yeah.
Representative Lauser.
I think, so I see where Representative Pyle's going. In the sentence prior to that, the commission may do one of three things: issue an alleged violation, require additional investigation, which is action being taken, or close the matter. So then the next sentence, each case must be closed. So to me, I read that as if they have not issued a violation and they are not requiring additional investigation, which means the process is ongoing, then the third option is to close the matter, at which point it must be done within 180 days. There might be some clarity that's needed there, but that's how I interpreted.
Yep.
Okay, so we shared this portion of Representative Lauser's discussion. And I want to point out that what Representative Lauser is talking about is Section 7 of the Ethics Commission's budget bill. So he is talking about the portion that is the issuance of an alleged violation / closure of a matter, which reads, upon completion of an investigation, the executive director shall prepare a report and recommendation to the commission to close the matter or issue an alleged violation. The commission may issue an alleged violation, require additional investigation, or close the matter. Each case must be closed within 180 days of receipt by the commission of the underlying complaint. So this language talks about, what he is talking about is the language in Section 7. And it seems to be that there's a little bit of confusion about how the process happens and when this 180 days really starts or what the intent of it is. He talks about the fact that the commission may issue an alleged violation or require an additional investigation, or at that point close the matter. So it's really clear, based on what Representative Lauser is talking about, is that there's some confusion in this section. The reason that there is confusion in this section is because this portion of Section 7 was originally part of House Bill 1360. And it added terms and phrases and processes that don't currently exist in the complaint process. So without the other portions of House Bill 1360, the first two sentences of Section 7 really don't function within the current complaint process. You would need to add the rest of House Bill 1360, or at least House Bill 1360 in portions, in order to get this first part to work. For example, currently under the complaint process, alleged violation is not defined. That was in House Bill 1360. The process of issuing an alleged violation, requiring additional investigation, or closing a matter, all was within House Bill 1360. So including that here really does not make sense for the following sentence about closing the matter. So this really does emphasize the need for more education to make sure that our legislators and that our stakeholders and the public understand the complaint process, because we're trying to change a portion of the complaint process that basically doesn't exist as discussed. So I think we can move on and talk about, we have 3 short clips left. Let's go to
Thank you, Mr. Chairman. And maybe Representative Lauser can answer this. I think Representative Pyle it's getting to the point. So with the 180 days, so if we're truncating that process and putting a time limit on it, I can understand from the point of individuals that you're seeking to, interview witnesses, so forth, they're dragging their feet, they're not complying. So at some point, there has to be an end point. However, the individual that the complaint may be made against not responding and dragging it out and just hoping to get to 180 days. So what you stated, if that is in fact potentially taking place, or that there is a process by which the Ethics Commission can still move that issue forward, and it goes beyond the 180 days. I think you indicated that. I just want a clarification on that, if you would, please.
So with Representative Wagner's comments, there's just one thing that we want to point out in particular. He talks about people dragging their feet, and the deadline has been referred to as a tool to help the commission address closing these things. But the actual tool to facilitate the commission's work to complete an investigation would be a subpoena. And that's a common tool that's used in other civil litigation or civil investigation contexts to make sure that people are complying and that you can interview witnesses to learn the truth and get the facts. So that's the tool. It's not closing the complaint because someone's uncooperative. That allows them to drag their feet and be uncooperative. Yes, it incentivizes them to do that. So there's really two sides of the coin to Representative Wagner's answer. You can either provide the tool as a clear subpoena process to facilitate investigations and closing the commission's work out, or you can just direct the commission to shut down its investigations, which it appears they're trying to do with the 180-day deadline.
And that's the difference. The first one, getting the ability, if we had the ability to subpoena so we could get the information we needed, that's a tool. The 180 days is not a tool.
Yep.
So, yeah, the next clip is a question that Representative Pyle asked, so I'll have Alicia. Stand by, we're having technical
together the policy. Was the Ethics Commission thoroughly engaged in this process?
Thank you, Mr. Chairman. I know they reached out to him, worked with him in the first half of the session, where a lot of this work was done. Again, this was given our task to us by leadership to bring all parties together, because quite frankly, before crossover, the parties weren't getting along, and there was a lot of discussion and a lot of discord. So we were asked to step in and work on this, and we worked with the different agencies, with the Attorney General, with the Governor's office, and with others to do that. So to answer your question, if they were brought in on our end, no. Maybe in the first half, but a lot of this language came from those discussions in the first half of the session.
So, Commission, I just want to be very clear for the Commission that when Representative Pyle asked the question, Representative Nathy responded. He discussed the earlier discussions that we had been having with legislative leadership, with legislative counsel, not with the Attorney General's office. We did discuss with the Governor's office. Early on in session, that was about House Bill 1360 and 1505. I want to just let the Commission know that our staff, or I don't believe the chair was ever brought in on the discussion of a 180-day deadline. So I want to make it very clear that we were not consulted. And that was the question that Representative Pyle asked, and then Nathy confirmed that we were not brought in on their end, meaning once it was in committee in our budget bill. And we have last one, Commission.
Mr. Chairman.
Representative Kemp.
I just want to make sure I understand. So like the 180 days, if there's no action, like what just got explained, if there's no investigation, no further action other than this takes place. Am I correct? That this 180 day would be, because they are, I mean, it isn't a court, but the accused has a right to a speedy outcome.
Well, I was just going to thank you, Mr. Chairman. Representative Kempnich, that's exactly it. And you said something I wanted to say earlier. people in the court system have a right to a speedy trial. And unfortunately, with some of these complaints are just languishing there, and it's hanging over people's heads. So they have every right to have this moved out. So, and again, if the 180 is too short, if it causes issues, we can come back next session and adjust it from there. This is not written in stone. But I say we do this again. One side says they would have the ability to do without it, and the Ethics Commission says they don't. So we're going to give them this tool. And if it doesn't work, we can always adjust it later.
Again, we're having this, I guess I'd call it a recurring theme throughout, that referring to a deadline as a tool. But as we've discussed, that does not help the commission facilitate or complete its work on complaints. And another point that we thought it was important to address is Representative Nathie refers to speedy trial rights of criminal defendants. I just want to clarify for the commission and for anybody who's observing today that respondents to commission complaints are not criminal defendants. That reference does not help with reducing the negative connotation that's associated with the commission's process. It actually does the opposite and kind of feeds into this weaponization narrative of what the commission actually does and its work that it does with the complaint process. The more common parallel that you can make is the commission's process is more akin to civil litigation. Litigation, again, in that context, it can be complex, and that's why litigants have discovery tools at their disposal, like subpoenas, requests for depositions, requests for documents, etc. But again, the commission, as we've discussed, doesn't have those tools readily available to it. So here we have a process without those tools and with a deadline on top of it. And just for the commission's information, we went back and looked, and we could pick out about 13 older complaints that we could finish and close soon if we had a clear subpoena process to get the information we need to close those out.
So Commission, that concludes kind of our review. Instead of us explaining to you what legislators said, we let their words speak for them. We hope that that was helpful to you. I know you guys get sick of, maybe I don't know, but we like you to hear from people other than Logan and I and Alicia on these sorts of things. So what I would like to get from the commission or have the discussion, and I don't know if we necessarily need a motion, but I want to go back and talk about the directives that I got at the beginning of session, or that the commission staff got at the beginning of session regarding Senate Bill 2004. So the previous directions that we've gotten from the commission is to prioritize receiving or ensuring that we have that FTE, the education and communication FTE. That is going to maintain as our priority. We listed that as priority 1 in our request to the governor, to the legislature. We are going to maintain that as our request, as our priority to get that FTE. We also do have a few kind of smaller items that have either gotten missed or just need to be cleaned up in conference committee, which is what will happen in the next few days. We will go to conference committee, but I'm assuming that I presume the Senate will not concur. They maybe haven't concurred already. I'm not sure if I think they will not, but we're going to maintain focusing on the FTE. And then our secondary focus is hopefully getting as clean a budget bill as we can. And by a clean budget bill, what we mean is one that is not full of policy that could create potential issues down the road. Now, we know that that may not be possible and that we may need to do some negotiating, but as we are doing that, we want to make sure that we are prioritizing the FTE. And so unless the commission has other or further directions for our staff, that is what we are going to maintain. And we will certainly keep you updated as we keep going. So I think that's with that. I'd like to open it up to the commission to give me any further directions, comments, concerns that they have.
Is there still any possibility of a subpoena power?
sure, Ron.
You know, like, they did keep emphasizing this speedy trial business, which, as either you or Logan said, really is not very applicable here because we don't have a civil or a criminal defendant. And as lawyers know, Murray knows, and you guys know from being in a federal criminal court, it is just as likely that a criminal defendant will delay proceedings as much as the prosecutor will. In fact, the prosecutor a lot of times wants to move something along, and he or she can't do that because of the holdups on the defense side. So, as I'm not sure which legislator mentioned that, this right to a speedy trial is it's a false argument. And that would that doesn't help the 180-day argument at all. I'm sorry, I'm forgetting our chairman's first name, Dave. As Dave said, it is not a tool. So it would be certainly nice to get that. I suppose we can wait until 2027, but it'd sure be nice to get it now.
Rebecca, you ask, what issues you want. And to me, one of the biggest issues is this 180 days. I don't know how we can get rid of that, but that complicates matters and makes things much worse than they are now. I just see that as just a huge stumbling block.
Yeah, and maybe to follow what Ward just said, somebody explain, where are we at? In the bigger picture, and with the various pieces of legislation we had brought forward, this bill, through this Appropriations Committee, SB 2004, we're talking about money, our funding, our budget, right? And then somehow it got all muddied with policy language. So how do we get that stuff out of there? Can we, what's the process? And then is there any other pieces of legislation that we should be paying attention to besides this one?
Cindy, so to answer your question, where are we at in the process? On Senate Bill 2004, and that's the only one we put on the agenda for today. So with Senate Bill 2004, it's been through the Senate, and that's done, and it went over to the House, and the House made changes. The two big changes on a money side was the FTE and the $50,000, nope, just the FTE. And then the House added all the policy language. So now it will go back over to the Senate, and the Senate has the ability to concur or not concur. And I'm guessing there's so much change between the two that they likely won't concur. And most I'm getting confused. Most budget bills don't go to a conference committee. So then the next step that we are in is if the Senate doesn't confer, then you have 3 people from the Senate side and 3 people from the House side get together and they try to reach a reasonable resolution. So that's going to be the process that starts in the next few days. So we're going to have 3 people who are on the committee from the Senate and 3 people from the House, and they are going to have to work out their differences. We do not have the ability to testify. We can provide them with information, but in the committee work or in the conference committees, the only opportunity I get to respond is if I'm pulled up or directly asked a question, or Alicia, something like that. And so it will be between the Senate and the House now to decide what gets included ultimately in this budget bill and what is left out.
Okay.
But we
Do
can
we,
obviously, oh, sorry.
well, excuse me for interrupting you, Rebecca. Do we have a sense at all of what the Senate side's going to do? And it's Senate appropriations, right?
It is Senate appropriations, Cindy, that's correct.
And do we have any sense at all that, so they sent something different that the House has altered?
Yep.
And so we can like keep our fingers crossed that the Senate's going to take it back to where it was, where we want it.
So I think, the one thing that we will start doing at this point is once the conference committee members are selected and assigned, then we'll start communicating with those people, with those legislators, to share our concerns and hope that they can articulate that and negotiate, etc. So that's the direction that we are going to go. I think because of the significant differences between the Senate and the House, I think the probability that the Senate concurs is probably pretty low. Now, I'm not basing that on any data other than instinct, which isn't something I should necessarily use, but I just don't think they will because of the amount of differences between the two.
Yeah. Okay. Thank you.
Well, Murray wants to respond.
No, I want to concur with what Ward said about the second priority would be to get rid of the policy language, but if they keep the policy language, get rid of that entire section 7, which includes the references in 1360 and also includes 180-day language, is to entirely delete that section.
Yeah.
Which would address the concern that Ward had, and I have, and everybody else has. And I think, and I'm just suggesting here, is that if the House conferees demand on keeping the policy language in, I would suggest repealing 546607, which requires the mediation, because that's a time-consuming. If that could be removed, that would eliminate the time-consuming work up front that puts you all in an awkward situation. And everybody's talking about time it takes, and everybody's talking about weaponization and the complainant driving the process. If that section could be removed so that the complainant would have no responsibility for input after filing the complaint, I think it would be a much better situation. My thoughts.
Well, Murray, if I understand what you're saying, I may have to disagree with you a little bit. The mediation, it seems to me, is still a tool we should be able to use that may be helpful in some cases. And so I'd hate to see that leave completely. But that's what you're suggesting, isn't it?
It is, but you have to remember that I've been on the commission 6 months and you've been on the commission forever. So I will defer to your judgment.
Well, no, go ahead.
I was going to ask a question, Ron. So if the mediation wasn't between the complainant and the respondent, but instead between the commission and the respondent, what are your thoughts on that?
I think that'd be fine. I think as long as we have some tool that we could use, and I see Murray's point. I'm going to say some tool to facilitate settlement of some kind, whether it's between us and the respondent or between the complainant and respondent. I think that we should keep that tool, even if it takes more time. And along those lines, even though we've got some cases that are languishing a little bit, I don't think that's due to us. We try to move the cases along as quickly as possible, but you know, way back, I liked the idea that we were not part of any branch of government, that we weren't legislative, executive, or judicial, and that we would have the independence to do some things on our own. We have talked about this in the past. We are constrained a little bit by the language of the Constitution, but the Constitution, Article 14, could have been drafted a little bit better. Now, that's not our fault. And so, you know, we've got to work with the tools we've got, I understand, but I would hate to lose mediation as a tool. No matter who it's between.
So Ron, I think there would be a way to address or modify, amend 546608 to do that, to allow for a mediation. But have it between the commission and the respondent. That's also something that is consistent with what other ethics commissions across the country do.
And it's consistent with what the commission proposed in 1360.
Yes.
Yes.
It's not a good idea.
Okay.
I amend my suggestion accordingly.
I mean, the commission, you recall Rebecca and Logan and other legislative personnel, they worked hard on 1360. Rebecca did a lot of work, Logan did a lot of work. We tried to address the bottlenecks. That's what we've heard. We tried to address the bottlenecks, and that bill was killed. So, and that's the whole point. The comment about lack of leadership, that's not true, because we tried to set up a solution to the bottlenecks. They didn't like it. So it appears they don't like our leadership.
Well, I resent that. I resent that comment and the milquetoast comment. I don't think those were called for at all. As far as I'm concerned, our leadership is excellent.
Well, and from my perspective, it also, I don't know what the right word, again, so please excuse me. I know I'm on public record here, but it justifies this education thing. Because they don't obviously, and not that everybody needs to know all our details of our processes, but there's got to be some common sense applicability that, you know, here we're building this thing, here's how it works, and help us, we're trying to fix it, you know, and that, but yeah, but I agree with Ron that, yeah, that some of the comments in there are very upsetting. I'll leave it at that. And to maybe for me, bring us back to full circle, Rebecca. what, so 2004, where are we at again? Remind me. I know we started this meeting, you gave us an overview, but what are we getting in the budget? And based on what we asked.
Yep,
Just-
what are we getting? Let's talk about that, Cindy.
Yeah.
Give me 1 second. I want to find the document so I don't state something incorrectly. So in our ask that we made to the governor and then to the legislature, we asked for 9 different items that we had on there. And what we are getting additional requests at this point, right? Now we have to remember we're in the 3rd period or 4th quarter, whatever you want to say. We've still got a little ways to go. So right now the education and communication administrator is out. That is not decided on. We do have $50,000 for a case management system. That is a one-time funding. If we do that, though, there is going to be an ongoing appropriation that is associated with that. Neither committee addressed that. So that is going to have to be addressed in the conference committee. We asked for $50,000 of rules implementation. That was not added by either house. We asked for $50,000 of additional professional fees. Those were included by both houses. We asked for approximately $43,000 for commissioner pay increases that we needed to do because of a salary increase that happens in statute, and for temporary salaries. That we also got. We asked for approximately $32,000. I've lowered this to $25,000 for a workload increase, specifically for Alicia's position. I believe that was overlooked in the Senate, and there was conversations that they were trying to make sure that it was not a one-time thing. So we are going to bring that up again in the conference committee. They allowed, or they included $19,000 for additional IT and subscription services that we need to maintain. They included approximately $7,000 in travel expenses that we needed, and then $2,000 for furniture, or approximately $2,000. So what we did not get, I gave you the whole rundown of our 9 requests. What we currently do not have is the FTE for education, the continuing appropriation for case management system, the $50,000 for rules implementation, and the approximately $25,000 for workload increases. So that is where we are as of today. And we will prioritize that FTE, but also I'm going to have to have discussions about the workload increases or increase that we do need, and then also the ongoing appropriation for the case management system and rules implementation. So the rules implementation, neither chamber even had a discussion on that one. We brought it up and it was not discussed after that.
Well, and if you can, excuse me again for interrupting, Rebecca, but use, and I don't know this person, but Representative Hanson's, she did such a nice job summarizing that we're stymied, and here we're stymieing them worse because we're not funding them. And that they, the committee, should be funding us.
Yep.
Yeah. So use that language.
Okay. I will do that, Cindy. So priority-wise, we have the FTE, but then we also have the additional workload increases, the ongoing appropriation for case management, and the rules implementation.
During today's White House press briefing, President
I would say those are the correct priorities, particularly the FTE. That has to be our number one priority. Our staff has done tremendous work. It's got to be the smallest staff for an ethics commission in the country. And yet we're, with the level of work, with the complaints coming in and all that, and trying to follow the procedures that has been in statute for us, that's just not possible with the small staff we have. So we need that FTE.
Yeah, I agree. And same thing, I'll ditto my comment. Use their own language and turn it around. The way they talked about us and, all our delays. Well, duh. I got more to say about that, but not on the meeting. But so, for me, I listened to the hearing, I read the transcript, and then everything that you've highlighted through today's meeting, and that it's just like, well, duh, here's the justification in and of itself, exactly what you're saying about these delays and processes. We don't have enough staff, and yes, our staff are excellent, and the amount of work that does get done, yeah.
But Cindy, there are only 3 of us.
Yeah.
And you're remarkable.
And we have to sleep at some point.
Exactly.
Maybe that's just for me. Maybe Logan and Alicia sleep more.
On the day.
Depends on the day, yeah.
Any other comments? Ward, anything? Ron?
No, I just, the FTE I see as a priority number one. And then I still just struggle so much with that 180 days. I just see that as not working at all. And I can just see if someone has a charge against me that's legitimate, if I can stall on that, which is easy enough to do, I can get it to thrown out, which is just not right.
Yeah, I concur. That 180 days is not a tool.
It is not a tool.
Is there any chance that and I know Murray and Dave, you're kind of, because you guys sit in Bismarck, but where the commissioners themselves, where we should be available?
Well, Murray's been pretty active.
I've tried to it. Since I returned, I've tried to be at the legislature virtually every day.
Okay. Thank you.
We've put Murray to work.
Yeah.
We needed more staff, so.
Yeah.
Cindy, I also think that's a good question, though, to ask about being present during potentially conference committees. Let me get back to you guys on that one. That might be a great idea that I hadn't thought of.
Because sometimes just having a cup of coffee with somebody.
Yes. Okay.
Any other discussion or comments? Anything further?
Nope, we just had Senate Bill 2004, and I don't think we need any motions because you guys have previously directed me to do what I need to do, but it just reaffirms the direction that we're going to continue doing.
Yeah, as a commission, I think we firmly believe that we need that extra staff. Our current staff is doing things far beyond what should be required of 3 people. So, you all know how hard they work. So, Cindy, you're right. We have an excellent staff. Okay. Anything further?
Are we still meeting next week?
Yes.
Okay. Just want to confirm.
Cindy, I don't think it's going to be a super long meeting.
Okay.
All right. So this was a special meeting with that one topic only. So we've completed our discussion. So this meeting is adjourned. Thanks everybody for joining in.
Bye, everybody. See you next week.
Thank you.